started. I do expect a few more people to come, but we want to encourage people to be on time. I'm Margot Landman, Senior Director for Education Programs here at the committee. We are delighted that Aaron has agreed to speak to us about his very important paper, which I can't hold up because he has it. Here it is. On Chinese workers, lawyers, legal aid, the general situation, legally speaking, for lawyers. He is going to give a presentation, and then we will open it up for questions and discussion. I'll turn it over to you. Thank you very much.
Okay. Thank you, Margot. It's a pleasure to be here. I've been to a lot of National Committee events. I've never been to their offices, so this is certainly a first for me. It's nice to see old friends here as well as some new faces. My name is Aaron Halegua. I am a lawyer as well as a consultant here in the U.S. and also have been doing work in China for over a decade at this point, focused mostly on issues relating to labor, the legal profession, and dispute resolution there. So it's a pretty exciting time, I think, in the world of Chinese labor. There's a lot happening in terms of reforming the laws. We read about strikes, things at Walmart and Coca-Cola plants. Unfortunately, we have a limited amount of time, so I'm going to talk sort of about a sliver of that. But I'm going to try to keep my remarks short so that we can have time for questions for whatever it is people are interested in. I'm happy to discuss anything sort of related to the topic. So I'm going to talk mostly about the report that I did, but I always like to start off with this one slide to just keep in perspective of what we're talking about and the scope of what we're talking about when we think of Chinese workers, right? So I think that this slide does a pretty good job of showing just sort of the vastness of the Chinese workforce. I think another thing to keep in mind is that obviously it's a pretty diverse group of people as well, right? You know, the situation and the experiences of a migrant worker on a construction site, in Beijing, let's say, is going to be different and face different issues than a worker in a Foxconn in southern China, right? Differences in ages, differences in the types of jobs, and a lot of others. So I will speak probably at times with some level of generalization, but of course in China there's exceptions to every rule. So the report that Margot mentioned came about because the Ford Foundation had basically been funding some things in China trying to help protect the rights of workers. And a lot of organizations having done things for quite some time, the question just came up, well, what should we do next? And so they wanted to sort of take stock of what are the legal problems that Chinese workers face today? What are the services that are available in order to help them address those problems? And then where are the gaps and kind of what are the strategies forward? And that's pretty much the format that the report takes. In order the methodology that I used, there was a lot of desk research trying to get things publicly available and things from sort of internal sources within China, which often have some of the better data about what's really happening. Over 100 interviews inside and outside of China with a range of different people, from workers to lawyers, arbitrators, employers, human resource people, judges. And then the final piece that I'll talk about a little more is a study that we did looking at what are now publicly available court judgments to try to get a sense of what is happening in the court system. And I'll talk about a little bit more about how we did that and sort of what we found as we move forward. So I'm going to focus on a few sort of key findings of the report and kind of run through them, and then happy to take more questions about them later. And by way of background, I don't know sort of everyone's level of familiarity with how the Chinese economy and labor situation has developed over the last 30 years, so I'll do my best to explain it in about a minute. Urban workers under the planned economy were in the Danwei system, the work unit system. They had their iron rice bowl, right? So policy, government policy basically decided, who will work where. The provided for all of your social benefits. You more or less had guaranteed lifetime employment. All of this changed during the reform era when China decided it was going to move to contract-based employment relations, right? So it was going to be a market system. Employment relations would be defined by contract. And in 1994, they passed the first labor law, right? So that was to use law and statute to set minimum standards for workers, like we see in our own legal system and a lot of other market economies. So rules about minimum wage, overtime, maternity protections, maximum hours, and things of that sort. The other major transformation that happened was in the reform era, a lot of the rural population started to move to the cities in order to take jobs in factories in this fast-growing coastal economy, right? So investment was coming in. You had factories, private enterprises growing, particularly in the sort of Guangdong region, and migrant workers were the ones filling these jobs. Oftentimes, they were much more vulnerable and open to exploitation because they lacked a lot of social capital or social resources in the places that they moved to. And so a lot of what we're talking about is going to be focused particularly on migrant workers, which in itself is a huge population, but also sort of low-income workers generally, because I think in some ways the line between migrant workers and non-migrant workers is sort of becoming a bit fuzzier than it was 30 years ago. So with that being said, the first finding that I wanted to talk about was, so despite the reforms that have happened sort of since 1994, and then again in 2008 when they passed the labor contract law about 10 years ago, to try to address some of the issues that had arisen as they moved to a market economy and sort of contract labor, is that, of course, violations, like in our own country, still persist in the labor sphere. Just to point out some of them, one is unpaid wages remains a very big problem, particularly in the construction industry. You have people who literally months of wages that they have earned simply do not get paid. In a more subtle way, you have a lot of people who are working but not getting paid the overtime that they might be owed. And even though the government has focused on this unpaid wage problem for quite some time, official government statistics show that in the last year, the average amount of the number of migrant workers that have been affected by unpaid wages has actually increased, not decreased. Work injury, occupational disease, workplace accidents also continue to be a persistent and large problem. Progress has been made since 2000 in terms of the official count of number of workplace accidents that are happening. But even on a per capita basis compared to the United States or the United Kingdom, the rates of accidents and injuries are much higher in China. A final problem I'll mention is just pensions. Particularly for migrant workers, you have a lot of cases where employers have not made the required Social Security and pension contributions. And now as migrant workers, many of them are thinking about retirement, wondering about whether they'll collect a pension. They're realizing these contributions haven't been made. And that's been the source of a lot of grievances between workers and their employers. And so these grievances sort of manifest in two main ways that I'll talk about. The first is you could have an open strike, right? A work stoppage or some sort of collective protest that happens. And this is an example from a shoe factory in Dongguan where 40,000 workers went on strike in 2014. In the UAUN case or YY case, they make shoes for Nike, Adidas, a bunch of other leading Western brands. According to China Labor Bulletin, which collects statistics on this sort of issue, in 2015 alone, they found over 2,700 collective protests. That is probably a fraction of the actual number because these are only cases that China Labor Bulletin is able to, sort of verify that they got some piece of evidence that it went on. I think there's a lot of strikes that don't go reported, right, that are certainly not on the official media and might not make it even into social media or are taken off of social media before they can find out about it. I think one interesting number that I saw is the government's own reports, I think from 2014 or 2015, said that there were about 10,000 protests just by migrant workers over unpaid wages issues. And that was in 3/4 of a year, not even a full year. So of course it depends a little bit on what you count and how you count it, but I think what is pretty consistent is that this trend is increasing, that you have an increased number of sort of strikes, protests, and work stoppages. And as the economy gets worse, I think you're going to see more and more of this. The government, goes without saying, is not very excited about an increase in strikes. They don't like collective protests that sometimes are directed at the employer, but also sometimes are directed at the government. They don't like when workers go out and block roads or do anything that sort of threatens stability. And their preferred approach that they very much try to engineer is to have these workers and have anyone with a sort of grievance go into the formal legal system, right? And so you have a formal legal system that consists of mediation as well as litigation. If you file a claim before you even get to the court or get to labor arbitration, there's been a proliferation of different institutions that will all try to mediate your case, right, to reach a harmonious solution before you have to get into the litigation process. And in the last decade, we've seen a huge growth in the number of institutions that are offering this service, as well as the number of cases that they're resolving. If a case is not settled through mediation, you can file it at labor arbitration, which is essentially like a labor court. It's a government body that decides disputes, not sort of the private labor arbitration some of you might be familiar with, where the parties are, privately appointing an arbitrator to resolve it. It's essentially a government dispute resolution bureau. And if you're not satisfied with that result, you can go to court. If you're still not satisfied, you can go to court again. So effectively, you can have an arbitration, a first trial, and then a second trial after that. So the government would very much like you to go into this process, and certainly the number of cases we've seen over the last decade has been consistently increasing, as this chart tries to demonstrate. So if you add together the mediation cases plus the ones that are resolved by labor arbitration, it's more or less continuous growth in the number of cases that we're seeing. The other trend that I think is interesting is that more and more cases are being resolved through mediation. On two levels. First is you have more mediation of cases than are even enter into the arbitration system. And then once you're in the arbitration system, the government is still trying to mediate the case, right, to reach this harmonious resolution. And we see nationwide, 47% of the cases that get into arbitration are still resolved through mediation, as opposed to the arbitrator issuing an award. So there's a huge emphasis on this, and without question, the vast majority of labor cases in China are being resolved through mediation. The other point that I wanted to make that we tried to look at is, so what is happening when they do go to arbitration or go to court, right? Is this a process that's good for workers? Is it bad for workers? Do they win? Do they lose? And most of the evidence that I'd seen has all been anecdotal, right? So you talk to management attorneys who represent companies, and they tell you workers win in every single case, right? The law is so stacked against companies in terms of the burdens of proof and wanting to appease workers that management always wins. If you talk to labor rights advocates or lawyers who represent workers, workers can't get a fair shake, they don't have the right evidence, and oftentimes, judges are just pressuring them, and the litigation process is very, very hostile towards workers' claims. The truth is probably somewhere in the middle, and what I wanted to do was try to put some kind of number on it, right? Try to get some sense of what was happening in terms of that we could quantify, as opposed to just hearing different stories. So this is the official government statistics on the bottom here that you can look at in the report that talk about what's happening in arbitration. Again, most cases are mediated, so they're talked about as partial wins for both workers and employers. I think the other trend that we're seeing, though, is workers are totally winning in less and less cases each year, and the number of partial wins is increasing each year. What I wanted to do was also look at court what's happening, because I haven't found any official statistics talking about the rate of success by workers in court. And so what we did was, now that courts have been required to put all of their decisions onto the internet, into this database. They don't put every decision on. It's certainly an imperfect sample set, and there's a lot of methodological issues with it. but that's sort of the best we had. And so I partnered with a company in Beijing that does big data analyses of this database for all sorts of different legal issues. And we looked at all of the first instance labor cases for, I think, a 2-year period in Beijing, Shanghai, and Shenzhen. There's about 30,000 cases total. And it was a very simple analysis. We just said, how many times did the worker either partially or totally win on their claim? And we found that the number in court was 58% of cases. And we can come back and talk about, is that a lot? Is there a little? I think it depends how you look at it. But at least we started to have some number as a starting point for a discussion about what is actually happening in the court system. So the next area that I wanted to look at and that the report goes through is, well, what are the legal services available to workers, right? What is available to them? And the three things I'm going to kind of focus on are, one, that private lawyers still are reluctant to take a lot of cases representing workers, that these barefoot lawyers and NGOs have sort of been pushed to the side in the sort of labor law landscape, and how legal aid has largely replaced them. So in terms of private lawyers, I think we see it in our own country, you see it in every economy and sort of labor market or legal market. A lot of workers have claims that are not worth a lot of money. The labor process is complicated, right? You have to go through arbitration, you have to go through these 2 trials. So understandably, in China as in elsewhere, a lot of private lawyers are reluctant to get involved in these cases. You can definitely have a much easier time and probably make a lot more money if you represent employers. And I think we're starting actually to see in the Chinese market sort of lawyers who think of themselves as management side attorneys. And if they represent employers, they won't take on cases for workers. And then I think you have a few things that are sort of specific to the Chinese situation. So in America, for instance, a lot of labor and employment cases are brought by attorneys on a contingency basis. Right? I know you can't pay my fee up front, but if you win, I'll take a percentage of that. So technically that's banned in China for labor cases. You're not allowed to do that. So that makes the economics pretty hard. Another thing that makes the economics hard is that even though there's a process for class actions under the law, in labor, as in almost every other type of case in China, oftentimes I don't think many lawyers bring cases as class actions. And when they do, they find that the courts are not so willing to treat them as class actions. Far more likely to sort of divide them up into different groups of people, perhaps require multiple trials, which makes the whole process much less efficient, right? So whereas, if you have 100 workers with a claim that's worth 300 or 400 kwai, it's a lot of work to have to do 100 different trials, do the paperwork for 100 different people. If you could bring them together, it would be much more efficient. It would be much more attractive for lawyers to do that, but that's very hard to do in China. So this is a problem that I'd say has not really changed, but has persisted, where private lawyers are not so willing to represent workers. For a long time, even though there was a legal aid system, it was pretty small and hard for workers to access. And so what you started to see was the development of 2 things, barefoot lawyers and NGOs. So by barefoot lawyers, what we're talking about is people who don't have a legal license, don't have any formal training, and but we're willing to sort of represent claimants. And there's 2 points to note. One is that there was actually a legal provision in China that explicitly allowed for this type of thing called citizen representation, or gongmin daili, where any individual could represent any person in a litigation so long as they weren't charging a fee for it. And so a lot of people started to use this as the means to represent claimants who couldn't afford to hire lawyers. In the labor space, what you had was a lot of people who were really former workers. They themselves had suffered some kind of injury or some kind of injustice and worked their way through the legal system, developed this kind of knowledge and this passion for helping others, and they would go out and use this provision to represent other workers. A lot of them took a fee, they were doing it as a business, but nobody was really cracking down on it very much. And this grew tremendously. I talked to some judges in Shenzhen who around, in the early 2010s would say that maybe 50% of claimants in their court were represented by these barefoot lawyers. instead of lawyers. I've seen statistics even from Beijing in certain courts, particularly in the kind of outer counties that get close to this 50% number. So this was not a small piece of, kind of fringe thing that was happening. This was a major part of who was providing these services and willing to represent workers in this litigation. There was also a nexus between sort of labor NGOs and Barefoot lawyers, because where you had some people that were really just doing it kind of as a business, as Barefoot lawyers, you had labor NGOs that, oftentimes had foreign funding, perhaps weren't charging any fees to the workers, coming at it from a more public interest sort of vantage point, also using this citizen representative provision to provide legal aid to workers. I think what we saw, though, over the last maybe 6 or 7 years in particular, was that the government policy towards these groups changed somewhat, or certainly evolved in some ways. And there's actually a document that came out in 2009 that basically makes the case that the reason people are turning to Barefoot lawyers, turning to labor NGOs, is, we're not doing a good enough job of providing them legal services. And this is a problem because these labor, to some extent, these Barefoot lawyers and labor NGOs are unregulated, right? Unlike licensed lawyers who we, grant them their license every year, these people are harder to control. They get involved in these collective cases. They might get involved in cases where they, influence the parties that, you shouldn't just go to court and don't just go to arbitration, but you'll get a better result if you also block the road, or you also, sort of approach the government and put some pressure on the government. And so they were very much seen as kind of instigating some of this labor unrest. And the government took an approach of how are we going to combat this? How are we going to sort of move them aside? Well, we need to replace them with something. And so they said, lawyers have been very unwilling to kind of get involved in this space. We need to increase government legal aid. And we need the trade union to start doing more and to provide its own legal aid while we sort of move Barefoot lawyers and others out of it. And that's exactly what we saw develop after this document was issued in 2009. In terms of Barefoot lawyers, you started to have judges that would say, we're only going to let a Barefoot lawyer do 2 cases a year in this court. Or they would say if the Barefoot lawyer wants to do a case, they're going to need to get a document from their hometown that certifies that they've never been involved in it. They don't have any criminal background. All sorts of measures just to make it more and more difficult for them to stay involved. And then finally, what we saw in 2012 and 2014 was actual changes to the legislation that allowed for citizen representation that made it much harder, almost impossible, for people to use this procedure anymore. And we saw a huge drop in Barefoot lawyers. And one guy I talked to in Shenzhen said, a few years ago, maybe you would find 100 Barefoot lawyers that were just focused on labor cases. And now it would be hard to find even just one. So a huge drop, almost cut off in that entire area of service. But one thing that has happened in response is that government-sponsored legal aid has increased and increased dramatically. And so the way that legal aid works in China is it's essentially a government-funded program, controlled through the Ministry of Justice. And certain regulations are issued at the national level about who's eligible. Localities are allowed to expand the net of kind of who qualifies for legal aid. But a worker will go to the legal aid office, which is, again, staffed by civil servants, bureaucrats. They will make a determination as to who's eligible. And if you're eligible for legal aid, what they usually do is then give the case to a private law firm along with a small stipend that says, do this case, we'll give you 2,000 or 3,000 kwai to do it. Regardless of whether the result is good, the result is bad, whether you spend a year or a month doing the case, you'll receive this fixed stipend. There's problems and criticisms that have arisen that, law firms' incentives under those situations is to do the case as quickly as possible, spend as little effort as possible, give it to the least experienced person in the firm to do it, because, we're going to get 2,000 kwai either way. Let's do it in the least painful way to the firm. Nonetheless, it's undeniable that a lot more legal services have been provided to workers as part of this system. So just looking at the official statistics of what's happened, you can see huge growth in the past decade in the number of civil legal aid cases that happen. Right, so well over 1 million cases a year by 2014, and I think about 400,000 of these cases deal just with labor issues, mostly unpaid wages as well as work injury. Right, so a huge part of this legal aid system is really just getting at this labor problem. And migrant workers in particular. I think, again, about 1/3 of all legal aid cases involve migrant workers, which is a huge change if you go back to around 2004, 2005. It was extremely hard for migrant workers to access this local legal aid system. There were actually requirements that, we were only going to help people who are from this city. But there was a specific government intervention at the national level that said in 2006, all of these requirements about whether you make the financial means test, right, whether you're essentially poor enough to qualify for legal aid, we're getting rid of that for migrant workers. So migrant workers who have a labor case, who have an employment case, sort of automatically qualify for legal aid. And certainly there's still instances where the process doesn't quite run that smoothly, but you can see in a lot of cases, it does work, and these migrant workers will receive help from a lawyer through the formal legal aid system. So where does that leave us, though, right? You have this huge loss in Barefoot lawyers. You have lawyers who are still kind of not excited to represent workers, and this huge jump in legal aid. And so what I wanted to know is, okay, so what does that mean, right? What number can we what do we have to try to understand of whether workers can or cannot get help when they have a legal grievance? And so, again, there's not good data that I've found on this. And so in order to take just kind of a first step at it, we did this analysis of the 30,000 cases and just saw in how many instances did the worker have some kind of legal representative with them. And what we found is that it averaged to about 59% of cases the worker did have some form of representative, 6 out of 10, which frankly was more than I was expecting. And there's a lot of caveats to it, right? This is only looking at Beijing, Shanghai, and Shenzhen. It could be very different in other parts of the country. Also, sort of who is doing the representation we know does vary. So in these big cities, you're more likely to have a lawyer doing it, whereas in a place like Jilin province, we saw that it was much more likely to have someone like a basic level legal worker, right? So someone who charges less, maybe has less formal training, essentially more of almost paralegal, but certified paralegal, representing you in this case. But it was good to at least, I think, put some kind of number on, again, where we stand in order to have a sense over time. We can see, is this increasing? Is this decreasing? Are workers able to find representation? Are they not? I mean, the thing to note, though, of course, is while we're talking about 6 out of 10 people with legal representation of some form, I think this is really the tip of the iceberg that we're looking at, right? Because the group of people we're looking at, you have to think of there being a pool of people, of workers, right, who have some sort of grievance, right? Of those, there's a fraction who actually discover that they have a legal claim. And there's a smaller piece who actually think about doing something about it, right? And then there's the smaller piece of ones who actually seek out legal help, right? Of that, there's a fraction that actually receive some kind of legal help, right, that file at arbitration, and after arbitration continue on to court. So this is only the people that not only went to court, but even went through the entire judicial process and actually had a verdict issued in their case. Right? So a lot of workers have been kind of weeded out along the way. So I don't think this means that 6 out of 10 workers who want legal aid or want a legal representative can find it. I think the number is much lower for that. But again, it's at least a starting point to look at what's happening at the kind of top of the system, at the tip of the iceberg. For instance, one study that was done in Chengdu looking at arbitration, right? So it's kind of the step before you get to court, found that 36% of claimants had some kind of representation. And I think if you go further down the pyramid and look at mediation, a lot of people are still unrepresented at that phase. One mediator I spoke to in Beijing estimated that only 5% of workers who go to this kind of pre-litigation mediation have any sort of legal representative with them. So again, just important to note that when looking at this statistic, it really is the tip of the iceberg.
Would the other side have legal representation?
So we looked at that number. It's a little bit higher for employers. I think in mediation, they're more likely to have some kind of representative, although not necessarily a lawyer. It might be, sort of a human resources kind of company at that stage, or some kind of other, advising professional. But yeah, the numbers weren't hugely different. So what to do about this representation gap, right? And what the report tried to do was think of a few strategies that sort of make sense in the Chinese context that can be used to narrow this gap between the need for legal services by workers and the actual availability of legal representation. And so I'm just going to mention a few of them. I'm happy to talk about any of them if people are interested in discussing it further or have questions. I think one that's interesting, mostly because it seems sort of obvious, but it came up with every single NGO that I talked to and every single labor advocate, is the need for continued education to the workforce about what their rights are. So even though the government engages in a lot of these sort of PUFA, right, sort of campaigns to teach people about their rights and spread knowledge about the law, a lot of workers, right, aren't focused on that until too late, right? At the time that they're working and still in their job, they really don't know what they're entitled to. And a big part of this, I think, is also the high mobility of a lot of the migrant worker force, right? So a place like Foxconn will tell you that the average length of someone's job at Foxconn is maybe 3 months before they move on, right? So even if you invest a lot in terms of teaching people about what their rights are, right, you're going to do a training every year to tell people what they're entitled to, right? You're going to need to do that actually more frequently than that in order for people to learn, what their status of their rights are under the law. Another thing that I think is interesting is sort of anti-retaliation. So in our own country, the United States, we have pretty strong laws that forbid employers from retaliating against workers that complain about violations or that actually bring a lawsuit, right? There's punitive damages, all sorts of penalties against employers who do that. Nonetheless, we still see a lot of retaliation, and understandably, workers are very afraid to come forward with a complaint because very few believe that they can, tell their employer that they're unhappy and unsatisfied and they think they're breaking the law, that the employer will just say, oh, okay, great, we'll take a look at it. Thanks for bringing it to our attention. In China, the case, I think, is even worse because even that protection under the formal law, you don't really have in most cases. And so I think one thing that we can sort of look at is it's only a starting point, but we've seen China introduce anti-retaliation measures for whistleblowers. We see it in the labor law for instance, complaining to the Labor Bureau, but there's no general protection and strong penalties for workers who just complain to their employer or who bring a lawsuit for some kind of labor violation that they've experienced. And so that's one strategy I think China can look at, expanding what they've already done for whistleblowers in another context to a more general population and protection. Another one is about developing the plaintiff's bar. And so I think some of the problems that I talked about in terms of why lawyers are unwilling to represent workers are things that could be adjusted and changed, right? So the thing about contingency fees and not allowing contingency fees is something that's within the possibility of reform. Class actions, like I mentioned, there's already a provision in the civil procedure law, and it's really just a function that it hasn't really become real, and courts haven't really been willing to allow groups of workers to proceed in this way. The foundation is there, and I think if you make that more robust and allow workers and lawyers to use these provisions, it could create a lot of opportunities for attorneys to be incentivized to provide this kind of representation to workers. And another focuses on deterrence, right? So actually limiting the number of violations that happen in the first place by making employers realize that, there's high stakes for this. So interesting, in the United States, we have personal liability for employers who don't pay wages to their workers. And we also have, criminal liability in some cases for individual employers. In China, there's no civil liability for individual employers, right? If you go to court for the wages you haven't been paid, you can only sue the corporate entity, but you can't sue the individual. And so as you might expect, a lot of these entities then turn out to be bankrupt. They turn out that their assets suddenly disappeared, right before you were getting ready to enforce the judgment, which makes the whole exercise hard to go through, hard to collect, and discourages a lot of workers and a lot of attorneys. Right, so looking into personal liability is one option. In China, you've already seen actually the introduction of criminal liability for individuals. So they've established a crime in 2011, which is the malicious non-payment of wages. So essentially what that means is if you have a judgment against you already, and at that point you then transfer assets or take steps to kind of make it hard to collect on that judgment, that can be a crime. And they've started to pursue this more aggressively. I think up until now they say there's been about 400 cases in China where they've had criminal prosecution for not paying wages. So this is an area where I think they could do more and continue to do more. And one idea is to really work with labor advocates in this regard, right? If labor advocates understood better sort of how do you package these cases so that the prosecutors are willing to bring the criminal enforcement, right? What kind of evidence do they need? They're the ones who are interacting with the workers on the front line. They can sort of find the cases that are appropriate for criminal prosecution. And I think more of these can happen. I think labor advocates can also be more effective in spreading some publicity about the prosecutions that do happen, because the only way that deterrence works is if employers really start to think that this is a true possibility, that it's happening a lot, and there's a good chance they're going to get caught. And so this is an area that I think China is on a good path in terms of trying to deter the most egregious practices. And I think more of that, hopefully, can have the effect of decreasing violations at the outset. So there's other recommendations up here. Again, some focus on sort of decreasing the demand for legal services, some focus more on increasing the supply of legal services, all with the idea of narrowing that representation gap. And so I'm going to stop here. Those are kind of the issues outlined and topics outlined in the report. But I'm happy to take questions really about anything that's happening in China related to labor relations, or I guess anything else you want to ask.
Thank you very much. Do we have any questions? Yeah, Bill, please identify yourself.
Bill Armbruster, retired journalist. Very interesting presentation. Are there many legal suits brought against foreign employers, particularly U.S. companies, maybe also the contractors, like companies like Foxconn, which is a Taiwanese company but works for U.S. companies like Apple? Can you comment on that?
Yeah, I mean, there's a lot to be studied, I think, sort of in that data set. Beyond the kind of things I've talked about, we haven't run a lot of those numbers yet. I think there are a lot of cases. I think the question is, right, is it disproportionate to the number of people they represent, or disproportionate to kind of their size or stake in the workforce?
I would like to think that the U.S. companies treat their workers better.
Yeah, so I think I haven't looked at, that's my sense, right, is that U.S. companies say that they have, kind of less violations and less kind of litigation that they experience. But I think a lot of companies, right, or less and less companies are sort of directly hiring their own employees. A lot of the biggest operations are supply chains, like you mentioned, like Foxconn or Pegatron. And then you hear other stories that some of maybe the Asian-invested factories in China might even be worse than some of the Chinese factories. So I don't have the statistic for you. I mean, I've definitely seen cases against Foxconn, but I haven't sort of looked at it in terms of, is it a disproportionate kind of number compared to cases against Chinese enterprises? But definitely something we're planning to look into.
Frank.
I have a technical question.
Who are you?
I am Frank Kale, at least last I checked. A technical question and a grand question. The technical question is, on the screen there was a phrase, legal minor. I think I know what that is, but can you tell me what a legal minor is?
Sure. Do you want to do both of them?
The grand one?
I want the grand one too.
Okay, the grand question is, I may have been out of the room at the time, but I don't think you mentioned the All China Federation Trade Union, which would seem to have a role somewhere in all of this, somewhere. And I'm guessing that the role is not much, but I'd like you to suss out what it's doing, and is it just tamping down fires?
Yeah, no, that's a great question. I'll start with the hard one. So Legal Minor is the company in Beijing, the name of the company in Beijing that does this big data analytics using the database of court judgments. That's all. So if you want to learn more about them, you can go to their website. They actually have several interesting studies and kind of not just labor, but different aspects of law, these empirical studies of what's happening in the court system. You're absolutely right. The trade union is definitely a huge part of the landscape. In terms of what they do, just sort of the background and primer for those who don't know, there is one official union in China, which is the All China Federation of Trade Unions. For the most part, I would say it functions like a government bureaucracy, right? They have their head office in Beijing. There's branches at the provincial, municipal, and district government. Technically, they're called a mass organization, right? So there's like a women's federation that represents women. There's like one for disabled people that's supposed to represent their interests. There's one for workers, which is the All China Federation of Trade Unions. In practice, I think they essentially function like government bureaucrats. Their salaries are largely controlled by the local government, and they're responsive to that. At the local level, sort of the enterprise level in a company, for a long time there's been a problem where you don't have elections of the union officials by the workers. Usually it's someone who's appointed by management. To the extent that you have elections and experiments with elections, oftentimes management will control who can be a candidate. And so, to make a long story short, I think the union has not been seen by workers as someone who really represents their interests. And so they've made themselves kind of irrelevant to this discussion of where am I going to turn when I need help with a case. I think part of that is, you have good people in the union who want to be doing more, who want to be representing workers more aggressively, but there's constraints because of sort of their function as essentially an arm of the government. And so if you look at the laws that govern unions and what they're supposed to do, it's much more about maintaining stability, mediating, right, being that bridge that helps workers and employers talk peacefully, not about sort of vigorously representing workers. Interesting, though, in this context, one thing that the union has started to do is provide legal aid, because they've seen this as a space that's sort of, it's kind of in line with what the government program is, right? That labor disputes should be channeled to the legal system. And so similar to the Ministry of Justice, the union has started a program where they pay private lawyers also to represent workers in litigation, which I think says a lot about kind of how the union views its roles and what it can be doing to contribute to labor issues.
Did you want to ask something?
Yeah, should we let the guest to ask a question? Okay, well, thank you for.
Identify
Oh,
yourself.
sure. Halegua of the National Committee on U.S.-China Relations. So thank you for a brief presentation. It's marvelous. I have, I'll just ask questions. Towards the end, you talked about this criminal prosecution of not paying wages, and you're seeing more of that. But actually, last year, the case, and actually there was a trial that was the opposite. There's also now a charge, a criminal prosecution against maliciously seeking unpaid wages. I know it was a big trial in Shanxi, I believe,
Yeah.
and several people were actually sentenced
Yeah.
So, but people never understood what's this charge about? What's maliciously seeking unpaid wages? I don't know whether you have studied that issue as well. But at the same time, people keep talking about there's a shortage of migration laborers these days. So does that mean like when it comes to labor disputes, now the workers have a little more leverage than before? And of course, you mentioned it and touched upon it. I always wonder of the 56% of the cases that went through the end that had got a verdict for the workers. How can they enforce it? How, what's the percentage of these plaintiffs can get that verdict enforced for them? What's the mechanism there?
Yeah, that was a great question. Good to see you again, Heini. So there's a few questions there. I think I know the case you're talking about. I'm not sure if the actual crime they were prosecuted under was maliciously seeking wages, or if it was the more general disrupting social order. But maybe the news reports talked about what they were doing was they were pursuing their wages. This was basically a group, if I remember correctly, of migrant construction workers who hadn't been paid. And as far as I could tell, there was no dispute about whether or not they were paid. I mean, it wasn't like the government was saying you had been paid and you're making this up. It was the fact that they chose to pursue it by basically protesting and blocking a road, things which are pretty common in China these days. And I think it sort of fits into the narrative that I'm telling about, the government does not want you protesting and striking in order to resolve these things. They want you to go to court, to go through this mediation, arbitration, litigation process to do this. And I think that case got a lot of attention because there was some kind of public sentencing, which I don't think happened. I'm not an expert on this by any means, but news reports say, is no longer a very common thing in China, raised sort of images of what had happened during the Cultural Revolution and the way you publicly sentence people. But I think the interesting takeaway for our purposes was, really trying to send a message that even though we know this is a problem with unpaid wages, the way to go about it is not protest, it's through the legal system. Enforcement is a huge, huge issue, both in the United States, and I'm part of a coalition here that looks at how judgments for workers often go unenforced. It's also a huge problem in China, not just for labor judgment, but all sorts of civil judgments. And if you look at the report, there's statistics about it. And so, one thing we haven't talked about yet, but I think is sort of a huge question, is looking more critically at this mediation process, right? If so many cases are being resolved through mediation, well, is this a good thing or a bad thing, right? Are workers better off under these circumstances, or, right? So the sort of best case scenario for mediation is workers are entitled to a certain amount of money. Mediation allows them to get it faster. The employer is voluntarily agreeing to the resolution, so there are not going to be appeals and they're not going to be challenging it, and they might actually enforce it, right? That because I agreed to it, I'm going to pay this judgment. So some would say that mediation is very effective in that way of kind of increasing this rate of enforcement. Other people will tell you that mediation, and particularly the way it happens in China, is quite coercive, right? And so what you really have is workers who are entitled to X, but are sort of pushed and not overtly threatened, like with physical danger, but a lot of pressure is brought to bear to say, you should really be settling this case. Your evidence is not strong. If you keep waiting, if you keep going forward, it might be years before you get a judgment. And even if you get a judgment, you're not going to be receiving any of it because you'll still have to enforce it. Right? That process can be viewed as a little more coercive, and maybe workers who are coming in owed, 1,000 kwai are settling for 500 kwai or 400 kwai as a result of this process. We don't really know very much about the outcomes, but I think it's a big question as to how important or effective is this mediation process. I think the short answer is, there's instances of each, because I've definitely also spoken to mediators that say, workers come in with basically no evidence. So even if they were unpaid, there's no way that a court would ever support what they're asking for. And in mediation, we're able to say to the employer, hey, come on, give them 2,000 kwai, give them 3,000 kwai, to make this go away. And sometimes they're able to achieve that. So, with millions of cases being resolved each year, it's hard to generalize, but I think it's important to look into what's happening with these mediations.
Joan, we'll get to you.
I had two questions.
Who are you?
Oh, I'm Joan Kaufman. I'm with the Schwartzman Scholars. I had two questions. The first question is, could you comment a little bit on the, the sort of tightening political situation of the last few years in terms of certainly human rights lawyers, but any kind of sort of civil action in general, I would say, the NGO world and the sort of crackdown on dissent and how it intersects with this issue of labor representation. And I'm thinking about the China Law Bulletin connected groups in Guangzhou in particular, and whether they've been particularly targeted, and what's the message there and what's going on. And the other question is about, to what degree do these legal organizations that are set up, do they also serve like citizen protests against like building a nuclear power plant, or pollution of the water, or the river, and other types of kind of localized protests that are happening to an increasing degree around China over these kinds of environmental in particular issues?
Yeah. In terms of the groups that I've talked to, most of them seem pretty solely focused on labor issues. I mean, some of the activists, like there's a guy, Zhang Zhiru, down in Shenzhen, certainly thinks about broader issues, right? I mean, I think one of his most notable actions was trying to run for the local People's Congress, for instance, and there was a lot of news and press around that. I think it was over a decade ago. So not strictly just a labor issue, but also participating in the democratic process and things like that. I think the situation has certainly gotten tighter. Certainly there's always ebbs and flows in sort of what NGOs report about how closely they're being watched, how much space they have to get involved in these sorts of things. If you read the sort of official Chinese media reports about the crackdown in December 2015, they make the case that these NGOs are not really just helping the workers to resolve the dispute. They're saying that they're actually out there inciting them, right? That they're the ones who are telling them to go out in the streets, when to strike, how to strike. I think they would accuse them of making up or exaggerating some of these claims. If you look at the CCTV reports about, why they were arrested, that's what it talks about. If you talk to the labor NGOs, I think they would say the problem exists, right? These workers were unhappy because they were unpaid by their employer, or the social insurance contributions hadn't been made. They wanted to take some kind of action, and we're actually the ones who are helping them to formulate their demands, to choose a representative structure to negotiate, yes, to think strategically maybe about how and when to strike, and how to use their leverage. So there's different takes on exactly what's happening, and I'm not on the ground, so I can't really say, but the effect, I think, is clear, right? After these people were detained and then prosecuted, I think it certainly had a chilling effect on other NGOs. I think the broader context of, the arrest and detainment of human rights lawyers and people we think of as Weichuan lawyers also has a chilling effect. And I think, people are sort of less willing to engage in the types of behaviors and some of these strike-related collective dispute activities than they were in the past.
Tyler Potter, associate at PwC. One of the things I was thinking about as I was listening to you is, what is the dynamic between the Communist Party's influence over the courts and the attempt to squash any type of class action suit? It seems that there's a systematic oppression going on from a legal perspective, not allowing people to organize to bring a case, and I was thinking, I was pondering kind of where do state-owned enterprises fit into this picture? If you were to bring a class action suit suit against a state-owned enterprise, what relation would that have to the government and therefore the courts? So they seem like they're very much in bed together, and I was just curious about your thoughts on those dynamics.
Yeah, no, that's a great question. I think not just in labor, but it's pretty well known in any sort of sphere that the party and the government is not very supportive of citizens' efforts to organize, come together for a common purpose outside the auspices of the party itself, right? They would say you should do it within the context of the official trade union or other avenues that we've designed for you. Any sort of independent centers of power are not really smiled upon. And I think that's true in labor as well, right? The idea of whether it's in a strike or a collective protest, right? People coming together maybe with a lawyer or without a lawyer, defining their common interests, protesting the government. They don't like that sort of thing happening. And I think, lawsuits are the same way, right? If you have 300 people in a lawsuit, it gives them something to organize around, some kind of collective common purpose. So I think that is one of the motivations for not encouraging this type of litigation. In terms of your second question, I think it's sort of a more general issue about political interference in the courts, which is like a hotly debated topic. And we all know it still happens. I think one thing we probably can say fairly safely is that it's more likely to happen sort of the higher the stakes are and the more politically connected one of the parties is, right? So we don't know quite how much it happens with a state-owned enterprise, for instance, but it's probably more likely to happen with a state-owned enterprise than it is with two private parties that maybe don't have such a close government connection. But the government interference, just one point to make is the government is usually interfering not always to the detriment of the workers, right? Because the government is so concerned about stability, right, and sort of resolving the conflict, that can also be beneficial to the workers. So I read about one case that, pretty proudly, the news release from the Legal Aid Justice Bureau talks about this case where there's like 600 workers who haven't been paid. They're starting to protest, and they did a great job of funneling it into the court system, right? So they got them to file an arbitration claim. They gave them 6 lawyers to represent them in different groups, and after the hearing, the next day, the politics and law committee, for that township got together. I think the subtext is decided what the results should be, and very quickly thereafter, the arbitrator gave a decision awarding money to the workers. And they were very happy, and it was resolved, right? They probably didn't go through all the evidence so rigorously for the 300 workers in that day before the meeting, but it got resolved quickly in a favorable settlement. So I think, yes, it clearly still happens. It's not always clear who the winner and loser is going to be, because I think it's a complex calculation for the government.
Larry?
Larry Goodwell. I teach in the business school at Pace University. I have a lot of students, by the way, from China. And one of the questions for the future of China is the whole area of the rule of law. Is China making progress in the rule of law? And I mention this in the context of the government is providing legal aid. So why are they doing that? And how does that relate to the possibility of a gradual improvement in the rule of law in China?
Yeah, I think this question is sort of, on some level, the $10 million question, and also the hardest to answer, but not just to avoid it. I think there is a real issue of what do we mean by rule of law, right? Because there's a lot of different things you can look at and measure, right? So yeah, if you look over a 20-year course, right, there's more lawyers, there's more court cases, there's more laws, there's more judges, right? All of those are potentially indicators. If you talk to some scholars, they say the fact that you're going from, going to this system where there's this huge emphasis on mediation, for instance, they would view that as a sort of retreat from rule of law, right? That everything should be decided basically on politics and, right, other considerations other than the law. So I would kick it. Is there anything in particular when you say rule of law that you have in mind?
Well, the idea particularly that disputes that are in the private sector are going to be resolved in a legal way rather than a political way. I thought the mention of the state-owned enterprises was a good one, because that obviously would be more political. Throughout all your remarks, I've been thinking, this idea of unpaid, I mean, here I think in the United States, if you're an hourly worker, you're supposed to get paid every week. How does this work that you're unpaid?
Yeah, I mean, I think where the problem is most poignant is in the construction industry. And so the way that it functions is you have a construction site, you have workers coming from other provinces, and basically they say, we're going to provide your food, we're going to provide your housing, and you're also going to get a wage. And so what will often happen is, maybe the first month they pay you, the second month they pay you, the third month it's, we're a little short on money. It hasn't come down from the developer, right, to our project manager, to the labor contractor, to us. So we'll give you half of what we owe you this month, but we're going to, when we sell the condos at the end, we're going to give you everything, right? You say, okay, well, my housing is taken care of, my food is taken, I can live and survive, I'm going to keep working, right? And that happens the fourth month, that happens the fifth month, maybe the sixth month, they say, we really don't have any money to pay you this month. But you kind of still have this subsistence provided, and so you keep working there. And this was a problem back in, the 90s, in the 2000s, that received a lot of government attention, but still persists today.
Is it only in the construction industry?
No, I would say that's sort of the most common, where you have this kind of large-scale kind of like withholding of wages. And then what happens is at the end of the year, right before Chinese New Year, it all comes to a head, right? Because the worker in Beijing wants to go back to their family in Sichuan with a bundle of money to pay for whatever it is, their kid's education and their ailing parent, and they don't have it, right? That was the whole purpose of coming to Beijing for the year. And so that's when, if you look at the China labor strike map on a monthly basis, you see right around Chinese New Year every year, right? It's like a huge spike in the number of strikes. And so it happens in all sorts of industries. I mean, it definitely happens in manufacturing and apparel, the same thing, Maybe they live in a dormitory, they're not getting paid every month what they say, but as soon as this shipment is done, as soon as we get paid by the brand, we'll have the money to pay you out. But not surprisingly, often that money never comes through, or all of it doesn't come through. So unpaid wages is, I should say, is sort of a general term to catch a lot of different things. It could be blatant, just we never paid you. It could be we paid you a portion of what we were supposed to. Or it could be a legal violation, like, we paid you, but we never paid you the overtime that you should have gotten. And I think depending on which sector you're looking at and where you're looking at, different types of violations are more or less common. Right? So amongst, more skilled workers, it might be more of an overtime problem.
Dr. Liu will give you the last word.
Last word. Starting from you, I have a question about the development of plaintiff's bar. Because although there are not a lot of lawyers take on labor cases, there are some. So I'm just wondering if you can talk a little bit about who they are and how specialized they are. Are they just focused on labor cases, or labor cases just 10% of their practice?
Yeah. So my sense is there was only one firm I ever heard about that was specifically focused on doing labor cases on the plaintiff side, which was Duani's firm, Laowei, in Shenzhen, that probably a lot of you have heard about, which I think was a bit of an anomaly and sort of surprising because it's so uncommon in China. I think we've seen the development of firms that focus on labor and represent employers, but I haven't seen anything like that, with this one exception, on the plaintiff side. So I think what you have is mostly people that have general practices, will take, not in a, will take whatever, their practices take whatever case, comes in, and therefore I think often aren't extremely specialized in this area. What you do have that's interesting is, in Beijing in particular, you have groups like Zhicheng, which is a sort of an NGO staffed by licensed lawyers that only do labor cases. There's another one, Yilian, in Beijing, that only do labor cases. And they've developed, quite a high level of specialization, although you still have, I experienced it as a legal aid lawyer in the United States. People think that if you're free and you're not charging for your services, well, there's no way that you're as good as the guy who's willing to take 2,000 kwai from me in order to represent me. So there's still some of that happens, but they're probably amongst the sort of most specialized plaintiff lawyers. And I think what was interesting, if you talk to these Barefoot lawyers that used to exist in Shenzhen, they would tell you that they are much better at, they know much more about not only the labor law on the books, but also sort of how to work the courtroom and how to work the arbitrators and sort of achieve a successful result than a licensed lawyer would be, right? Because they are solely focused on labor cases every day and built up this kind of expertise. And it was the same thing when I was a legal aid lawyer. One of my responsibilities was to do unemployment hearings, right, which was one of 5 types of cases that I did. We had paralegals who don't have a law license, but only did unemployment hearings every day. And so when I had a question about procedure or, right, how to do something, I'm going to the paralegal and saying, can you explain to me how to do this? So the idea is not that crazy that, you would have these sort of people who are more specialized and focused on this one particular thing become much more expert at it. And just as a closing point, another interesting comparison with the United States that, I know something you've thought about and focused on is when all countries have a legal services gap, right? There's always more people who need legal help than legal services that are available. And if you look at our housing court in New York City, the last statistics I've heard is that amongst eviction people who are in eviction proceedings, over 90% are unrepresented. So this is not just a Chinese problem by any means. In terms of how to fill that gap, I think New York and a lot of places in the United States are thinking about how do we use non-lawyers in new ways to try to bridge this gap. Whereas, at least in the labor space, the Chinese approach at this stage of development, is not that, right? It's getting rid of these sort of unprofessional, unregulated Barefoot lawyers and replacing them with only licensed lawyers, right? And giving them a bigger share of the market and phasing out some of these other less qualified people, which again is just an interesting thing to note, and we'll see how it plays out in the coming years.
Thank you very much. We've run out of time. I do believe Aaron will be willing to speak informally, but we must let people who need to go leave. Thank you very much. It was really
My pleasure.